Welcome to the deep dive. Today, we're stepping into a legal area it's often missed, and simple mistakes can have really serious outcomes.
That's right.
We're investigating the critical, sometimes tricky world of including firearms in your estate planning.
Mm-hmm.
And this isn't just, adding a shotgun to a list of items. It needs a much more careful approach.
Absolutely. Estate planning generally aims to transfer assets smoothly, but firearms, they're under this unique, often complex web of rules.
Rules, okay.
Yeah, federal laws, state laws, they have very specific requirements. And overlooking these, well, it can put your heirs in real legal trouble.
Okay, let's break that down. Why are firearms in this separate box? I mean, when you think about passing things on, it might not immediately jump out that a firearm needs this whole different legal treatment. What's the fundamental reason?
Well, the core reason is that firearm ownership and transfer are just strictly regulated. Think public safety concerns.
Right.
So, unlike, say, furniture or jewelry, transferring a gun is subject to specific laws controlling who can legally have them. And these laws, they vary hugely between states.
Hugely, okay.
Oh, yeah. A transfer that's totally fine in one state could actually be a serious felony just across the border. So your standard estate plan, the one for regular personal property, it's just not enough for firearms.
Wow. So just listing a gun in a will,
Right.
the way you might list a watch, that could accidentally put your beneficiaries in a position where they're breaking the law without even realizing it.
Precisely. An heir might think, okay, the will says this is mine, and take possession, only to find out later they're violating federal or state gun laws.
And that leads to...
Well, it could lead to criminal charges, pretty hefty fines, and the firearms themselves could be confiscated.
Okay, this sounds like a potential minefield. Our source material from Tactical Edge magazine, it mentions something called a gun trust. What exactly is that? How does it help here?
Right, a gun trust. It's a specific kind of legal entity designed purely for owning and transferring firearms.
So like a regular trust, but specialized.
Exactly. It operates like other trusts in some ways, but it has provisions built specifically for the unique legal hoops you have to jump through with firearms, especially certain regulated ones, like NFA items.
NFA items. Like suppressors or short-barreled rifles.
Yes. Things like that often fall under stricter federal regulations handled by the National Firearms Act. A gun trust is particularly helpful for those.
Okay, so it's a purpose-built legal tool. What are the real practical advantages of using a gun trust instead of just, say, relying on a will?
There are several big ones. First, and maybe the most critical, is legal compliance.
Making sure it's all above board.
Exactly. A properly set up gun trust helps ensure every transfer, all ownership, sticks to federal and state laws. It really minimizes the risk of accidental violations.
That alone sounds worthwhile. What else?
Second, privacy. Wills usually go through probate, right? That makes them public records.
Ah, okay.
But gun trusts, they typically avoid probate. So the details, what firearms are in it, who the beneficiaries are, that usually stays private.
That privacy aspect. I can see why that would be very appealing to many firearm owners. Are there other benefits?
Flexibility is another key one. You can have multiple trustees with a gun trust.
Meaning more than one person can legally handle the firearms.
Right. It allows others, maybe family or trusted friends, to legally possess and use the firearms in the trust, even while the original owner is alive. That can be really useful.
Interesting.
And then there's continuity. The trust lays out a clear, legally solid plan for managing and distributing the firearms if the owner dies or becomes incapacitated.
So it avoids confusion later on.
Yes, it prevents those potential arguments and makes sure the transfer happens exactly how the owner wanted.
It sets up that clear path, helps avoid legal issues, maybe family disagreements too down the line.
Yeah.
What happens if someone doesn't do this kind of specific planning? What are the risks we're really talking about?
The risks are pretty significant. We've touched on legal violations, heirs accidentally possessing guns illegally or transferring them improperly. That means potential criminal charges. Serious stuff. Then there's confiscation. If guns are transferred the wrong way, authorities might seize them. Your intended beneficiaries could just lose them completely.
Not ideal.
Not at all. And finally, the lack of clear planning can easily cause fights among family members. Who gets what? Who's even legally allowed to get what? Without clear instructions, it can create a lot of conflict and stress.
Yeah, those are major consequences. It really highlights why being proactive and informed is so crucial here.
Yeah.
So what practical steps can people listening take now to handle this responsibly?
Okay, step one, absolutely essential. Make a detailed inventory of every single firearm you own.
Every single one.
Every single one. Manufacturer, model, and most importantly, the serial number for each. You need that detailed record for any transfer or legal process down the road.
Okay, inventory first. What's next?
Second, and I really can't stress this enough, get expert legal advice. Talk to an attorney who specializes in both firearms law and estate planning in your specific state.
Not just any estate lawyer.
Right. You need someone who understands the nuances of gun laws where you live. They can give you advice tailored to your situation and the specific regulations that apply.
That expertise seems non-negotiable here. Any other steps?
Well, for many owners, especially if they have those NFA items we mentioned, or if they really value that smooth private transfer, setting up a gun trust is a key move.
So discuss that with the specialized attorney.
Definitely. They can tell you if a gun trust is the right fit for you and help you set it up correctly. And finally, talk to your heirs. Communicate.
Let them know the plan.
Yes. Make sure they know about the plan, about the trust, if you have one, and what their responsibilities will be regarding any firearms they might inherit. Good communication prevents future confusion and helps ensure everything happens legally.
Okay, so the big takeaways seem to be get informed, document everything, plan ahead specifically for firearms, and absolutely get specialized legal help. It's clear this isn't something where a standard will or just making assumptions will work.
Absolutely not. Thinking about firearms in your estate plan is really just part of being a responsible gun owner.
It's about protecting your legacy and your loved ones.
Precisely. It shows you're committed to making sure your firearms are managed lawfully, respectfully, and in a way that shields your family from legal headaches and personal conflict.
It's a serious thought, but a vital one for anyone who owns firearms. By really tackling these unique legal issues head-on, you get peace of mind knowing things will be handled correctly and your loved ones won't face unintended legal problems. It really underscores that responsible ownership doesn't end with safe storage and handling during your life, does it? It extends to planning carefully and legally for what happens next.